SJC-13551, Trustees of Boston University et al. Versus the Clerk-Magistrate of the Cambridge District Court.
Okay, we'll start with Attorney Pyle.
May it please the Court, Jeffrey Pyle for WBUR, the Boston Globe, and NBC 10. The Clerk-Magistrate did not abuse her discretion by deciding that these show-cause hearings should be held open to the public. The Eagle Tribune case and the complaint standards say that it's appropriate to open show-cause hearings where two conditions are met. An application is one of special public significance, and legitimate public interests outweigh the accused's right of privacy. Both prongs were clearly met here, and her decision to open the hearings was therefore not an abuse of discretion or error of law. There are three main reasons why that's the case. First, these applications derive from a federal indictment against an interstate brothel operation. These are not your typical district court charges. The indictment attracted national news coverage.
Counsel, can I interrupt you
Yes.
for a second, ask a question just about the facts? When did the interveners get notice of the request?
I do not believe, Your Honor, that the record is clear on that because it's my understanding the notice would have come from the clerk. There's no document in the record showing precisely when each of the John Doe parties got notice. Some of them stated in their applications that it was sometime in January. It's to my recollection.
And I'm sorry, so when was the request made to open the hearings?
The request was made to open the hearings in late December, I believe just before Christmas.
Were they given an opportunity to be heard?
Not in the sense of going before the clerk and asking that the hearings be maintained in closed.
Right, so I also didn't see any, I mean, thank you for whoever it was who submitted RA 35 because that was, I noticed it and I was concerned about that.
Thank you, Your Honor.
I take it that that request, as far as we know, was never received by any of the Does.
There is, as far as we know.
At least the record doesn't show it.
The record doesn't show that it would have been.
We couldn't assume that they did.
Correct.
We can't assume also that they received notice through some other means, correct? Other than perhaps some inference drawn from their own papers?
At whatever time they were notified of the scheduling of the clerk-magistrate's hearing, I suppose one could assume they received some indication at that point.
I didn't see anything on the docket.
No, Your Honor.
Okay, well, the docket is the official record.
Correct.
Right. So, and to the extent that there are any individuals who may have received some form of actual notice, let's call it, we can't say, I take it, that all of them did?
Well, it depends on what time, I think, what time frame we're talking about here. The request for access was made just before Christmas. That was granted, I believe, just after Christmas. The request for the applications was made on or around December 27th. By early January, we filed our application for emergency review. I believe the date there is January 12th.
Right, so let's talk about, though, before the motion to open the hearing was allowed, do we have any information in the record that the Does were given notice and an opportunity to be heard?
No, Your Honor. We do
Okay.
not.
And my second follow-up question for that is, everyone seems to treat all of the Does as a clump, as though every individual putative defendant or defendant, charged person, rights and interests are identical as a class. And I'm just unaware of any criminal case where that has been handled in that way. Can you point me to one?
We've pointed to one in the record. It was a single justice appeal involving the opening of a clerk's hearing where there was a large melee somewhere up on the North Shore, and the single justice treated all, I believe, 8 defendants in that case the same and opened up the clerk's hearings for them all as a group. And that is not inappropriate or an abuse of discretion under the standard that you have before you, where the court has to look at the general balancing the privacy interests, yes, of individuals against a general public interest in the incident itself. And in this case, you
Well,
have.
it might be if, I mean, in this case, the argument is that the balancing entails consideration of the defendant's status, occupations, things like that. So why wouldn't it be the case when those types of considerations are at issue that you would need to have some kind of particularized treatment?
Well, there's no suggestion that, there's no indication in the record that the clerk-magistrate did not review the applications themselves when deciding whether or not to open up the hearings. And in that sense, the clerk-magistrate, I think, can be presumed to have given some consideration to each of the applications when she decided to open them all up.
Why
Yes, she
would
treated
we
them-
make that presumption or assumption when she doesn't make a finding to say that she did that?
We know that all of the applications were also given to the single justice during the proceedings to decide whether or not she abused her discretion. The single justice had those applications, but it would seem to me that in reviewing this under an abuse of discretion or error of law standard, unless there has to be a showing of an abuse of discretion, and the showing of that she had all the applications, I don't think that one would necessarily presume that she didn't review the applications that she had in her file, or that the single justice would not have reviewed the applications as well.
She didn't make a finding either that she did, nor did she make a finding to say that she based her decision upon her review of those. So how do we get to that conclusion you're asking us to draw?
It strikes me, Your Honor, that one would presume that a clerk-magistrate faced with a request to open up the hearings would look at the applications before deciding whether or not to open up the hearings.
Is her differential treatment of the applications suggestive that she has done that type of individualized consideration, because she's treating the complaints differently because of the possibility of individual mistakes?
Well, certainly she is treating the complaints differently. And the question being, of course, the decision to open up the hearings happened before the decision to deny access to the complaints. But it does strike me as a safe assumption that the clerk-magistrate would have looked at the complaints in both instances. And returning again to the standard of review of abuse of discretion or error of law, when you look at the factual circumstances of these accused, they are alleged to have supplied the demand side for an interstate brothel operation that resulted in a federal indictment. And
I see your point on that, and I think we understand. Do you want to address the differential treatment of the complaints? Because
yes, thank you, Your Honor.
You want to affirm the first part, but you want to reverse the second part.
And
Yes,
before,
Your Honor.
while you're thinking about the answer to that, I guess I'm just wondering, practically speaking, why you would have appealed that order or her decision not to release the complaints or the names, when at the hearing you would have gotten that information anyway.
Well, Your Honor, we have a lot of experienced journalists who work for the Globe and for WBUR who have attended clerks' hearings before and have a lot of experience with how they operate in practice. And the concern was that when you go to a hearing, sometimes a name will get called out, say John O'Brien. And maybe John O'Brien is there in the hearing room, or maybe he's not. You're not required to be there in a clerk's hearing. The clerk-magistrate then said, okay, a complaint shall issue. And then that's the only information that anybody attending the hearing would have. You wouldn't be able to report which John O'Brien of the many that exist in the greater Boston area was charged with the
But
crime.
once the complaint issues, then you're in a different regime, aren't you? Because now there isn't a complaint, probable cause has been found, and presumably then the records are open.
Well, presumably after some period of time when the paperwork is processed, then maybe some days later there would be some release of
Oh,
documents. or
yes,
some
they'll be
ability to-
open. I mean, it's, because of the limits of reality, it won't be instantaneous. But why would it be a requirement that you get notice a day before, the day of, as opposed to attending the hearing and then having the corrections of any errors in John O'Brien's name be corrected at that point.
Well, when you look at the First Amendment and common law access cases, and I recognize this is not a First Amendment or common law case, they talk about how important it is that news media access be simultaneous with the actual event in court. Delayed access is not the same as contemporaneous access.
Right, but you
And
have the contemporaneous access, to the hearing.
to the hearing, but the concern, again, was it would be, in some cases, almost an anonymous hearing where you would not know exactly which person was actually charged, and what the news media, of course,
Because
wants
of
to do
an
is inform
inability
its
to
readers.
comprehend the name called? Is that
If in the case of a very common name, you wouldn't be able to distinguish who was actually charged without access to things like the address and the city where the person comes from. And also, there are some circumstances where the facts that underlie probable cause may not be completely recited in open court, such that the news media wouldn't be able to understand exactly what the reason for the probable cause determination was. There could be some parts of the police report, for example, that are skipped over and not discussed, and especially in the case of an accused party who doesn't show up, there wouldn't necessarily be a need for the police officer to recite every single last word of the police report.
Can I ask, in your briefs, you criticized the clerk-magistrate for not allowing sort of a last-minute distribution of the complaints. Did you even argue that to her?
Well, Your Honor, based on the way things happen procedurally, there was no occasion to argue that to her at the time because
brief it to her.
Because the hearings were scheduled to be heard very shortly after we made the request for the complaints. And then when we filed our single justice application on January 12th, the hearings were, our information was they would be held on January 18th. So we would have gotten those applications just before the hearing.
And here we are in September.
And here we are in September because now the matter was stayed after we filed our application and after we filed our motion, the underlying clerk-magistrate's hearings were stayed pending the outcome of this access question. But the standards that govern applications for criminal process are the same as those that govern access to the hearing. The complaint standards say that they are the same standards, and this court has treated them the same in the Globe case.
It's a balancing of interests, privacy and transparency.
In both cases, yes.
And she does a nuanced analysis of why we should treat the complaints differently, that there may be errors in them that could be corrected, that they would be released ahead of time, and then the people affected wouldn't have any chance to respond. But in a hearing, they would have a chance to respond. So she does a balancing of those interests carefully. Can we really find that's an abuse of discretion?
I think, Your Honor, that the abuse of discretion or error of law is the assumption that, as she says in the findings in support of her decision, that the release of the applications would have to be weeks or longer before the hearings themselves.
That's why I asked you that question. You didn't really argue that to her.
Well, no, we didn't argue that to her because of the
Timing of
the way in which
But the fact that you want the applications themselves and the reasons that you've articulated now at oral argument as to why really seems to me to buttress the clerk-magistrate's decision, because there's a difference in the level and depth of information available in the applications than might occur in the open hearings.
Well,
and so although the factors to be weighed are the same, the facts are different. And so the outcome, although initially maybe odd to open one and not the other, is understandable because of the level of detail in the applications that may or may not come out during the show cause hearing.
having not seen the applications, of course, we can only speculate. However, the U.S. Attorney's statement...
But you just did at oral argument right now, a few minutes ago. You said we need the applications because we are experienced with attending show cause hearings, and we understand that names can get botched, details like address, you know, whatever. The reason you want the complaint is exactly evidence that they're different in kind. And so to find that the magistrate the clerk magistrate abused her discretion would be difficult, given the differences that you've articulated well.
Well, thank you, Your Honor. I mean, my point in raising the fact that we have to speculate is not to disparage speculation in these circumstances. It's necessary. But when the U.S. Attorney announced the charges, they said, essentially, these people put their names into web forms with their name, email address, cell phone number, and place of employment, and a reference if they had one. And that the probable cause, I think, from the statement derives from the fact that they got all that information.
Not all that information is really relevant to the allegations, right? You're gonna release information on where someone works. I mean, I understand that may be important if the person works at the State House, but it may not be important if they work, at some business up the street that that the press and no one else has any particular interest in, right?
Well, what the U.S. Attorney has said is that these are high-level customers of this brothel who work in positions of public trust, including elected officials, public officials, high-level pharma employees or
Do you think a
scientists.
press release is evidence or to be given the same weight as an affidavit or some statement made under oath?
No, Your Honor, I wouldn't say as a general matter that a press release is of the same ilk as that. Notwithstanding, the public interest doesn't rely solely on whether or not the statement is sworn. What the public perception will be if these hearings are closed or if these applications don't allow for the proper reporting of these hearings is that anybody who is not charged will have done so, will have not been charged because they got some kind of preferential treatment behind closed doors at the hearing. And that is a significant concern, as this court has said in the Eagle Tribune case and in the Boston Globe case. And in fact, there's other parties here who have argued, well, what if there is no probable cause? Then I won't be able to get my reputation back. But this court in the Eagle Tribune case itself said that even when there is no probable cause found, that may be where access is the most important, because it helps to ensure the public that equal justice is being done among these different defendants who come from different walks of life.
Okay, thank you very much.
Thank you.
Attorney Urbellis.
Good morning, Your Honors. May it please the Court, Benjamin Urbellis for the John Doe Appellants. Just like grand jury proceedings, show cause hearings are presumptively private. And that's so that the livelihoods and families of those during an investigation aren't ripped apart before there's even probable cause found. That's been the standard with an 80-year history, including the legislature twice rejecting bills that would have made these hearings public. We're only here today because the United States Attorney made an improper comment about public officials being among the uncharged purchasers in a multi-state sex trafficking investigation with brothels from Massachusetts to Virginia.
What precluded the United States Attorney from making that? You say it's improper. Why?
I suggested it's improper based on Department of Justice policy where while there were indicted individuals in the federal case, commenting on uncharged investigations is against DOJ policy. I also want to point out that the Mass Rules of Professional Conduct has a specific section where it describes that prosecutors shouldn't be making comments on individuals that would heighten public condemnation. And with respect to that statement, it applied to this multi-state investigation from Massachusetts to Virginia. It didn't apply to the Cambridge John Doe specifically, and it's important to recognize that there were brothels just 14 miles outside of D.C., the hub of this nation's public officials. Now, unlike in the...
How does this statement that you're giving us affect our analysis as to whether or not the single justice abused his discretion when he concluded that the clerk-magistrate did not abuse hers?
Well, I think it's important to recognize that in the single justice's remand, he asked the clerk-magistrate to address several questions. Most importantly, how the public interest balanced against and he underlined individual privacy rights of the accused of these non-public hearings. She didn't address that.
Of course, no, she addressed that. I mean, you may not like the balancing she did, but she clearly addressed it and explained why she thought there was a significant public interest in assuring the public that powerful people would not be given preferential treatment behind closed doors. I mean, she explains that. You may think she drew the balance wrong, but our case law says she's supposed to do that type of balancing in a high-profile case, isn't she?
Well, I want to suggest that she didn't, when I'm saying that she didn't address it, she didn't address the individual, and that was specifically underlined by Judge Gaziano, because she didn't have the information about who these individuals were, what their privacy interests might be, what their occupations were. That was an individualized remand question that she didn't address.
But doesn't the public is confronted with the fact that it can't distinguish the individuals and will be worried that people are getting preferential treatment. So I'm just not sure how.
Well, I think that's a policy decision. That's not for this.
It's the legal standard, isn't it?
Well, I suggest that transparency and accountability.
That's in the Eagle Tribune. That's what our case says. Those are the factors you have to consider. Again, you have to balance privacy versus the transparency, but she does that. We don't get to rebalance it unless it's an abuse of discretion, right?
Well, I'm suggesting that she abused her discretion because she took that statement from the U.S. attorney to use that in her decision, and I don't think that was proper.
No one's filed a Board of Bar Overseers charge that's improper, including you, right? I mean,
right. Well, whether it's improper or not, it shouldn't be grounds. This vague statement about a multi-state brothel investigation or sex trafficking investigation to suggest that now 28 individuals with all separate interests should have their privacy rights stripped away because there's a chance that somebody within those 28 is a public official.
But that's not what she said. I mean, she said that there's this perception, if I don't open the hearings, that one or two or some of the 28 is getting preferential treatment if the complaint ultimately doesn't issue. And to avoid that and to, double down on accountability, she opened them all.
Well, I would suggest that if that's going to be how a clerk decides whether or not to open these hearings, that opens the door to now prosecutors are just going to leak information to the press and use that as a reason to have show cause hearings or even potentially grand jury hearings. If there's a leak that there's a public official among those being investigated by a grand jury, is this going to open the door to now TV cameras being within grand jury proceedings? So I think that should not be grounds to open up the hearings based upon the United States Attorney's statement.
In terms of process, what happened after remand? Was there a hearing?
The Clerk-Magistrate issued a response, and then the single justice issued his decision.
Okay, so there was, so the defendants were not heard, given an opportunity to be heard? Was there an opportunity given to be heard from the defendants upon remand?
No, there was not. And I also want to address the fact that upon the applications of the media to open up these hearings, the decision was issued 2 days later. The John Does didn't even know that they were defendants in this case, let alone notice to have an opportunity to be heard. And these are liberty interests because undoubtedly, even if there's no probable cause, once their name is out there in the media, livelihoods are going to be ruined, occupations likely lost, families ripped apart, their children are going to have to deal with this at school. So I would suggest that they did have a due process right to be heard.
And can you tell me anything about the status of Does 19 through 28?
I cannot. What I can say is that the 5 John Does that I represent are not public officials, and this would be stripping them.
I wasn't asking for anything outside the record. I was just, they haven't appeared. Is that correct?
I have no information.
Okay.
So just to follow up on Justice Wolahojan's question about procedure, notice was obtained at some point in January by the Does?
Correct, after the magistrate's decision.
After the magistrate, but before the single justice, or I'm just trying to get the timeline.
Yes, the notice was provided to the John Does, and several of which appealed
Okay.
to the single justice.
Okay, as interveners.
Yes.
Yes, okay. So at that point, upon remand, notice was had well, at least speaking for your clients, was there a request to be heard at that point?
I don't believe so.
Okay, thank you.
So explain to me the due process argument. So normally stigma is not enough for a due process violation, right?
Right.
So tell me why your case is different, because why is this different? Because we have a bunch of cases that say this doesn't rise to a due process level.
Right, well, stigma alone does not, but I would suggest that this is what's known as stigma plus. Given the salacious nature of the allegations in this case, and given the widespread media coverage, in this day and age where everyone has that information at their fingertips pretty much 24 hours a day, undoubtedly, the media is going to then lead to people losing their jobs and livelihoods, which is a liberty interest.
You said that in your brief, and you've said it now twice at oral argument. Why is that? How do I take judicial notice that undoubtedly these people will lose their jobs if probable cause is not found and no complaint issues?
I'd ask the court to do so.
And what would be my legal authority for doing that?
Well, I would suggest that, especially if people have, professions, professional licensures, I just think that it's common sense that, they will undoubtedly lose their jobs, lose their professions, and have their lives ripped apart.
I could see that. If the complaints had actually issued, I can see your argument maybe, but they're getting process. There will be a hearing, there's going to be process. We don't even know how this hearing would be conducted exactly at this point. The clerk-magistrate may put their own set of limitations on that hearing. So how does that really rise to a due process violation? Because you're going to have you're going to be there arguing vociferously. You're going to be filing motions, keeping your client's name as private as possible, I'm sure. So how is that a due process violation?
Well, I think that without giving them notice.
Well, they have notice now. There's been no release of these people's private information yet. There's full notice at this point. And they're all represented by counsel, I assume. And all counsel is going to be present at this hearing, arguing as effectively as you're doing right now.
Well, I would suggest that if there is a hearing prior to the show cause hearings where the clerk is going to take these matters.
We don't know how the hearing is going to be conducted. There's going to be process at that hearing. There's going to be a set of rules in place for that hearing, I assume. And there may be extra protections provided. We don't have any, we're not deciding how that hearing is being conducted. The question is whether it's public or not.
Right. Well, I'm suggesting that if this court upholds that decision, then that's what this is about. The show cause hearings will be made public. There's no way to prevent that from happening and prevent their names and their identities from getting out there.
Okay. Thank you.
Thank you.
Attorney Mahoney.
Good morning, Your Honors, and it may it please the Court. I think I'd like to start with the petitioner's brief, Mr. Pyle's brief, page 27. The petitioners may or may not determine that the identities of all 28 individuals are sufficiently newsworthy to publish in news reporting. So the Boston Globe would like all the information on all the individuals, while at the same time conceding that some of these individuals might not interest them at all, that they might not even be worthy of a line in the newspaper.
But the issue is whether the public is comfortable that there's not preferential treatment for the ones who are powerful. And how do you know if it's not public?
That seemed to be the primary concern of the clerk-magistrate, was the public perception that she might not be even-handed.
Right.
That seemed to be her primary concern.
But that's the judiciary's primary concern, that we're even-handed and impartial.
That's correct, and that's certainly the way it should be. Unfortunately, in order to achieve that goal, her decision results in other people who would not normally be caught up in this, would not normally be reported in the media, whose hearings would never be open. They're sacrificed. And do we want to sacrifice individuals to maintain the perception of the public or the media that this has been handled even-handedly? All of these
Would your
Test is a
concern-
balancing test, and you know, you call it sacrificing the individuals, but I think the test has been well articulated as a balance. And so sometimes the individual's privacy interests is overridden by the public interests in matters of public concern that have received the type of notoriety that this one has.
The brothel, in the potential participants, the customers, yes, and I conceded that in my brief. There are individuals, as I understand it, based on Acting Attorney Joshua Levy's statement, there would absolutely be a public interest. If politicians visited that brothel, that's a matter of public interest, for the reasons that I outlined in my brief. If someone with a security clearance could conceivably have been compromised, that's a matter of public interest. But when Acting U.S. Attorney Joshua Levy identified these individuals by profession, he didn't say firefighter or plumber or electrician, because nobody in the media would have cared. Mm-hmm. If those were the only professions that he listed, Boston Globe wouldn't be seeking permission to open the hearings.
Do you want to address Justice Wolohojan's point that she brings up earlier, that there has to be an individualized, separate analysis, that it's required as part of the process? Because I don't think you're going to get very far by just arguing the point you're arguing unless you sort of connect it to a legal point.
The legal point, Your Honor, is there should have been individualized findings, because if we look at the actual language of the statute, it refers to an application or it refers to an incident. This was not one incident. This wasn't like the other matter where there was a melee and it was all one incident. These are all separate incidents. These are all separate individuals who are being accused of these crimes, and they didn't participate in anything jointly. So for each individual, there should have been an assessment, because if an assessment is done and the individual is of no interest to the public, no interest to the public whatsoever, it does not hold an office of any note, no position of any prominence.
How can you make that determination as an abstraction? Okay, so one of your clients has an ordinary job. Doesn't work at the State House. We don't know if he's related to someone who works at the State House or is friends with somebody who has powerful connections, right? So I'm not sure how this works, because we can't judge just by someone's job whether they're connected, right?
I agree that I agree that that's a valid point, but I think that should be part of the clerk's analysis before she makes a decision for each individual. I know that the Attorney General has brought up the fact that this might be a difficult time-wise for the clerk to manage. But she could schedule a hearing without notifying the public. She could hold that hearing behind closed doors. And during the course of that hearing, she could make an individual assessment as to
But
whether or
isn't
not
that
this should be open.
exactly the situation that the clerk magistrate articulated she wanted to avoid? That she would be treating or perceived to be treating individuals differently based on position and power.
That is correct.
You have a behind closed doors hearing. Whether or not it's true, the perception is that people are being treated differently.
But may I say that in every clerk magistrate's hearing that is closed to the public,
Which is the default.
would that not also be a concern? That individuals whose matters have not been reported and do have some connections are in there in a closed-door meeting with the clerk magistrate and using the influence that that individual possesses to persuade the clerk magistrate to dismiss the matter? I mean, isn't that always a concern?
You're making her point.
Yeah, I think that's,
Yeah, but if it's always a concern, then why wouldn't we open all the hearings to dispel that concern? Why would the default position be that the hearings are closed? When that issue could surface in any hearing?
yeah, but
That
now
could-
we have a situation that has rightly or wrongly received public notoriety. And so we have these 28 potential defendants. And to treat them differently behind closed doors is the reason why the clerk magistrate said, I can't do that. It would indicate to the public that of the 28, a few of them are being treated differently, and the public would never know why.
In part of my brief, what I emphasized was that the system to function properly and to protect individuals like my client, it requires a certain amount of trust. And then I went on to say that we all have our positions, and certainly the justices of the Supreme Judicial Court are the highest attorneys in the Commonwealth, and you wouldn't have achieved these positions unless you were trustworthy. The clerk, Ms. Casey, she's a very trustworthy individual. There has to be at least some trust in the system for it to function. If everything was out in the open, if there were no sidebar conferences, because there would be the perception of the jury that information is being withheld from them. If the grand jury proceedings were open to the public, because there might be the perception that the district attorney's office hadn't presented the evidence in an objective and fair manner, then none of this, the system would stop functioning. So there has to be some things where there's some confidentiality. And everybody in, certainly the court and the clerk magistrate and Justice Frank in the Cambridge District Court have all earned that trust. There has to, we can't just, we have to have some trust in the system for it to function, because if there's no trust and everything is open to the possibility that there's some corruption or some undue influence, the system is going to completely break down. Because the purpose of these clerk magistrates hearings, in almost every case, and I've done a lot of clerk magistrates hearings in that courthouse, in almost every case, the probable cause standard is met. It's got to be greater than 90%. But then the clerk has some discretion. And that's where we, as defense attorneys, we explain to the clerk magistrate something about our client. And maybe our client could do some community service, or maybe our client could atone in some other manner, pay restitution to a victim. We talk about the history of our client and the personal attributes of our client. All of that is done behind closed doors because it really serves as sort of a criminal mediation. And when you open that hearing up to the public and its broadcast, then the mediation function, it doesn't really function as it's designed. And let's be honest, most of the defense attorneys and their clients are probably not going to attend, because we're not going to be able to make that presentation, because that's kind of the presentation where you reveal personal issues with your client or personal attributes. That's something that really is better done behind closed doors, where you can have a good conversation.
Thank you.
Thank you. Thank you very much.
Okay, Attorney Thornton.
Good morning. May it please the court, Assistant Attorney General Gabriel Thornton for the Clerk-Magistrate of the Cambridge District Court. The Clerk-Magistrate did not abuse her discretion in concluding that the public interest in accessing the hearings outweighed the individual's right of privacy. The Clerk-Magistrate appropriately supported her decision to open the hearings with the following findings. First, as to the public interest, she found that the underlying criminal case, quote, was widely publicized and the subject matter conduct generated significant interest by the public, close quote. Neither the petitioners nor the interveners dispute that finding here. Opening the proceeding for such a well-publicized case, the Clerk-Magistrate observed, could prevent questions of, quote, whether justice has been done behind the closed doors of the hearing room.
Could you address Justice Wolhojan's question about how individualized this process has to be? Because the clerk magistrate is dealing with them as a group. The way the U.S. Attorney's Office dealt with them is sort of as a group. And I'm just trying to understand, again, how granular this needs to be.
So when the single justice remanded the matter to the clerk magistrate, he ordered that she conduct an individual analysis. And after it was remanded, she considered all the different factors, certainly did not abuse her discretion, and determined that the interests in opening the hearings outweighed whatever the individual interests might be.
When you say she did that on an individualized basis, what in her decision on remand shows that she considered the does individually as opposed to a group of 28? Specific language would be helpful.
Yes, Your Honor. I can't think of any specific language off the top of my head. She did have the applications and the police reports in front of her.
Right, but that seems to me to argue against, to go run against this argument of yours, because with respect to the applications, she ruled the other way. You see what I'm saying?
I see what you're saying, Your Honor, but I wouldn't agree that it cuts against the argument, because with respect to the applications, the analysis still wasn't an abuse of discretion. It was, she could essentially consider them as a group of 28, just as she did.
Do we have any other balancing test in a criminal context where the defendant's privacy and also we're talking here about a presumption that ordinarily applies in favor of the charged person, accused person, where people who have committed crimes on different days, allegedly committed crimes on different days, there's no allegation that this is a joint enterprise on their part. They are charged individually with committing individual crimes separately on different days, that their due process and interests have been considered as a clump.
Well, it's not a clump. The federal case is unified, so we have a unified federal prosecution of the traffickers. But on the state side, this is going to be, as Justice Wolhojan said, an individualized one. So they're not a clump, but the federal organizing principle doesn't neatly apply on the state side, does it? Or does it? I just don't know.
I mean, pardon me if this doesn't directly answer the question, but if we go back to base principles of due process, there is no liberty or property interest here. There is no constitutional right that we're talking about in this context. We're talking about a Massachusetts statute.
So, counsel, are you saying, which is the government's position? Is the position that individualized hearings were not required because there's no liberty interest, or is it that per the single justice's order, the magistrate conducted and considered individually the complaints?
The former, Your Honor.
Okay, so she didn't consider the individual complaints as the government's position.
The government's position
And that
is
was okay because there's no due process implicated.
The government's position is that there's no constitutional or statutory or common law requirement of that nothing the clerk-magistrate did here was an abuse of discretion in terms of constitutional, statutory law or common law or the complaint standards, but that once the matter was remanded to her, she conducted the analysis that the single justice ordered.
Did the...
But I'm I mean, we have cases like this, protests, for example. 100 people are brought in at once, right? I mean, is there a legal requirement? I mean, at the show cause hearing, there's going to be an individualized analysis, right?
That's correct.
So, and the way the clerk-magistrate dealt with the applications provides for an individualized look in this interim period. So is there anything that legally requires her prior to the show cause hearing to, again, break this down individual by individual, or can she do it at the show cause hearing? I take it that's within her powers.
Your Honor, it wasn't an abuse of discretion here. I suppose if we look at some of the language, and there's not a lot of case law here, of course, right, but Boston Globe or Eagle Tribune, that there could be language there that suggests, at least in some circumstances, an individual analysis would be appropriate. But that
There is going to be an individualized analysis. The question is when, right? There has to be, there's going to be an individualized case-by-case determination, right? Because it's not a joint venture here.
Yes, Your Honor, there's going to be an individualized analysis for the probable cause determination, the determination whether a complaint should issue. There's nothing that requires necessarily an individualized analysis in the question of whether hearings should be open to the public or whether applications for complaints should be released prior to a hearing.
But if you have an individualized analysis at this point, don't you run into the problem where you're treating different people differently and the public doesn't know whether everyone's being treated fairly?
Yes, Your Honor. Certainly in these circumstances, the clerk-magistrate in this scenario, let's say 28 applications for complaint. Let's say she decided to open 27 of the hearings, but not one of them, or vice versa. Open one of the hearings, but not the other 27. The public would wonder legitimately, whether justice had been done. The court in Boston Globe, the 2019 case, talks about the interests of transparency, accountability, and public confidence in the judiciary. What the clerk-magistrate did here was in line with that language, and it certainly wasn't an abuse of discretion.
Do you have any authority for the notion that the request to open the hearings could be or should be allowed before any of the does received notice that the request had been made or an opportunity to be heard on the matter?
Your
I'm
Honor,
looking for some legal authority here.
Right.
Case, statute,
I'm not aware
rule.
of authority that necessarily points either way. Again, if we go back to basic...
Well, there is a presumption, right? So that's a legal authority pointing one way. It's hard for me, frankly, to conceive of overcoming a presumption or a presumption that runs in favor of a defendant without giving that defendant an opportunity to be heard. Because a motion was allowed here, and if I have the chronology correct, but correct me if I don't, the motion was allowed before any of the does received notice or an opportunity to be heard.
That's correct. That's correct. And again, if we go back to basic principles of...
But before any action took place, because of the single justice and because of the remand, notice was fully provided before any action, before the action we're dealing with was, right? The horse may have got out of the barn, but it was put back in before, right?
To be clear, the timeline, as I understand it, is media organizations asked for hearings to be opened. Clerk-magistrate decided that the hearings would be open. Media organizations then asked for applications for complaint. Clerk-magistrate said no. Media organizations filed the single justice petition. The record, it seems to me, is silent on when the John Does received notice.
And why is that not a problem? I mean, so these show cause hearings, as they're called, are presumptively closed. So that's a right that these potential defendants have, and it was taken away without so much as a word.
Your Honor, I'm not aware of any case law in the Commonwealth, any constitutional requirements,
But so in deciding whether to open the show cause hearings, the magistrate was supposed to consider the public interests against the interest in privacy of the individuals. And how could she have done that without even giving them the opportunity to marshal arguments, as they have here, as to why their privacy interests should trump?
Clerk-Magistrate's decision speaks for itself, and there was no abuse of discretion here. She did consider those factors, and there's nothing in this
But in
court's-
our legal system, we usually, it relies on, the so-called crucible of litigation. And in the absence, we have one side arguing one thing, and we have nobody on the other side.
Understood, Your Honor. Nothing the Clerk-Magistrate did here is contrary to the state's common law or statutory law. I suppose if this court wanted to prospectively, it could mandate.
And that may be just because no one's done this before.
It may be. It may be, but there's nothing in the complaint standards, and this court's decisional law and the appeals court's decisional law that required notice and a right to be heard in this context.
Can you address the stigma plus argument that this does rise to a due process violation because it's not just stigma, but it's going to have consequences? You may lose your job.
Yes, Your Honor. For there to be stigma plus, my understanding is there would need to be a denial, a deprivation of governmental benefits. We don't have that here. At least we don't have evidence of it. It seems it would have been easy enough for any of the John Does to put forth some sort of evidence of what type of governmental benefit they might lose or were at risk of losing, and that is not
When would they
happening
have
here.
done that without notice?
They could have done it before the single justice. They could have done it before this court, and they have not.
So you think that latter process fixes the original potential error in process?
Not necessarily, Your Honor, and again, I wouldn't concede that there was an error in the original process. Everything the Clerk-Magistrate did in the original process was in accord with the law of the Commonwealth.
Does I'm confused here, but I'm also new here, so do the parties normally have the ability to put new information in front of the single justice when they're asking the single justice to review the lower court judge's decision for abuse of discretion? Because I thought that wasn't allowed.
Yes, Your Honor, it seems like that would not be allowed.
Right, so going back to Justice Wendland's question then, when would they have had the opportunity to put in this additional information you're suggesting they could have when they didn't receive notice of the initial request and they can't supplement the record when it goes up before the single justice?
Although they could have even asked for the matter to be remanded for the Clerk-Magistrate to consider that information. But I think it's telling, especially where the John Does have not hesitated at all to argue facts, to talk about facts outside of the record. They did not list any facts outside of the record about what governmental benefits they might be losing.
And also, the issue is not a factual issue there. It's a legal issue there. The issue is notice and the ability to argue privacy versus accountability, right? That's what, we're not fighting the facts here or at the Clerk-Magistrate level until the hearing, right? So I'm not sure
That's
this
right.
is-
I mean,
Well, the hearing is the show cause hearing to determine probable cause as to whether or not they actually committed the crime suggested in the application. This is about whether or not that hearing will be public.
But, Your Honor, it's a matter of due process. It's a matter of constitutional law. The right to notice, the right to be heard, actually doesn't even arise until after the show cause hearing. It's a matter of constitutional analysis.
Is that substantive due process or procedural due process?
I believe it would be procedural, Your Honor. The notice and a right to be heard. I mean, the notice is the charging document, and the hearing is the arraignment.
So the test for opening the hearing, though, is a balance between the privacy interests of the potential defendants and the public interest. How would you get that first side if you don't have notice? I'm just a little stuck on that.
The side of the individual's
Yeah, you're supposed to
interests.
weigh the public interest against the private interest before you open it. That's the test, right?
Well, in this case, again, the clerk magistrate's decision speaks for itself, but there was no abuse of discretion. She clearly accounted for it. Could she have had more information? Of course. Could she have better information? Possibly, but she did.
Could she have information from the source whose interests were jeopardized? That doesn't seem required at all to you?
There's no requirement in the law of the Commonwealth for that.
So the only information, and I may be wrong on this as well, I understood she had was a press release from the U.S. Attorney's Office. That was the only, let's call it, factual information that she had in conducting her balancing of interests.
She had the applications for complaints and the police reports in support of the applications.
True.
And-
Thank
and
you.
I'm trying to understand the remedy. So when the clerk magistrate, after receiving the single justice questions, is she presented with briefing from the John Does or not? Does she have legal analysis from the John Does at that point?
I don't believe she did. I don't believe she had legal analysis from any of the sides at that point, but I may be wrong.
There's
on
no
that.
legal, so I'm just trying to understand the remedy if you lost. The remedy would be more that it would go back to the clerk magistrate with an opportunity for briefing by the John Does? Is that what because
I suppose, Your Honor, and it gets tricky, and in the brief, we argue the resources issue, and we argue sort of the difficulty of there being hearings about hearings or hearings about hearings about hearings.
Right.
But it certainly doesn't seem unreasonable for accused individuals, like the accused individuals here, to be given a chance to submit written materials, just in the way that the media organizations submitted written materials to ask for the hearings to be open.